morning, everybody, and a warm welcome to the Switalskis Court of Protection webinar series. I hope you very much enjoy these presentations over the next few weeks. It's always nice to have face-to-face meetings, and the MCA conference has been missed now for two years, and we're very much hoping that they will restart in the future and perhaps have the webinar series alongside going forward. I'm always very grateful to the speakers who give freely of their time and expertise to these talks, particularly to people that have frequently helped us with our MCA conferences, including our next speaker, which is Mr. Joe O'Brien. I need to go through a couple of housekeeping points. All our webinars are recorded and shared later on our website. The timings of the webinars are on our website. And to join our mailing list, you can go to www.switalskis.com MCA list. During the talk, please submit any questions via the Q&A facility rather than the chat facility, please. And without further ado, I'm introducing Mr. Joe O'Brien of Counsel, who probably needs absolutely no introduction to most of you. He continues to be involved in some of the most high-profile cases and reported cases in the Court of Protection. He speaks today about Hillingdon, best capacity evidence and disclosure in the Court of Protection. Two of the cases he will speak to today, he was involved in on behalf of P. Thank you, and I'll hand you over to Mr. Joe O'Brien.
Good morning, everybody. I'm so pleased to be here, and I'm so pleased that Switalskis have put on this series of lectures, which is a replacement for the annual MCA conference which they've had. And I look forward to a return to normality one day when we can all see each other, drink a bit, and eat a bit of decent food and have a chat at Switalski's expense. So I'm going to give an overview, first of all, of my presentation, and I'm going to look at three cases. The first, AMDC, which is a case about capacity evidence and how to approach capacity evidence. The second is case about the approach that we should have to Section 21A's, but also the court's approach as well to looking at capacity evidence on Section 21A applications and evidence generally in those proceedings. And the third is a case about joinder and the issue of disclosure. And that's quite an interesting case and an important case. So if I go to the first case, this was a case about AG and CI, and this is a case where they lived together in a care home, and they had formed a relationship having gone into the care home, CI having it been established that he had capacity, or there was no doubt about his capacity, to make a number of decisions on residence contact, sexual relations, etc. No issue about his capacity, but in terms of AG's capacity, there were a number of issues. And there came a point in the proceedings where a number of reports were collated by an experienced Court of Protection expert, actually, and a well-respected expert. And those reports were the subject of close forensic scrutiny during the course of a contested hearing in, I think it was October or November of October of last year, before Mr. Justice Poole. And just stopping there, Mr. Justice Poole is a relatively new addition to the family division of the High Court. But anybody who has had an experience of him sitting will know what an absolutely first-class tribunal he is, both in terms of his approach to the COP work and his understanding of the Court of Protection and what it's about and what the jurisprudence is about. And he's a very, very engaging judge, and very, very engaging in terms of how he approaches meeting protected parties in proceedings. So he was a relatively new judge, And this was not an easy case by any stretch of the imagination. And there were significant issues about the approach of the expert to the assessment of capacity and inconsistencies in a number of aspects of the evidence which had been filed by the expert. I'll just give you one example. It was accepted in the first report that P had a condition, an underlying condition, which was dementia, which could not and would not improve, and which over time would deteriorate. And in that report, there was some evidence to suggest that in some areas she lacked capacity. By the time of the second report or the third report, I can't remember which one it is, I don't think it makes a big difference. But there was a suggestion, in fact, that she had fluctuating capacity. The inference being from that from the previous report, she had in fact regained capacity, which was unlikely on the basis of his evidence that her condition could not and would not improve. And there were a number of concerns as well about the quality of the expert's engagement with P, particularly in terms of what was described by the expert as the brick wall, which is the significant difficulty in getting P to engage in the exercise of the assessment. And all this led to a contested hearing at which the expert was cross-examined, and that led then to an interim judgment, and it'll become apparent in a moment why. I think I want to start off by saying how Poole approached the issue of capacity. He drew down on a recent decision of the Vice President in PB, and he emphasised, first of all, what the Court of Protection is about and what the obligation of the court is about is in relation to protecting individuals. And he emphasised, this is Hayden J. in the Tower Hamlets case, that the obligation of the court is to not just to protect P in terms of the physical, emotional and medical welfare, but it extends in all cases and at all times to the protection of P's autonomy. And that's a really important starting point for everybody involved in mental capacity work and also the Court of Protection, which is you're not primarily just concerned with looking at the outcome in terms of protecting P, their physical, their emotional, or their medical welfare, but you should at the same time be striving to protect their individual autonomy. And we see this particularly so within the context of the question of a person's capacity. Moving on to the next slide, the judge emphasised that the only presumption in the MCA is the presumption of capacity, and that is the paramount principle. And the Vice President emphasised that the presumption can only be displaced by cogent and well-reasoned analysis. And we'll come on to see that just doesn't apply to expert evidence, but it applies to everybody undertaking a capacity assessment for the purposes of determining whether, under the principles under the MCA, an individual lacks capacity. The other matter which the Vice President emphasised was that at Roman numerals 5 on this slide, which is that the criteria for assessing capacity should be established on a realistic evaluation of what is required to understand the ambit of a particular decision by the individual in focus. The bar should never be set unnecessarily high. And this was very important. This follows on from the case of Re B in the Court of Appeal. The criteria should not be confined within artificial or conceptual silos, but applied in a way which is sensitive to the particular circumstances of the case and the individual involved. Now, that's a really important developing line of jurisprudence, in my view. And I'll give you one example of where we need to look and focus in on this, and that's the issue of capacity to consent to engage in sexual relations, where we've been at times rigidly applying a test of capacity which looks at the mechanics of the act, sexually transmitted disease, the risk of pregnancy, and the ability to say no or yes. And sometimes two of those parts of the test, sexually transmitted diseases and pregnancy, have been applied in circumstances where it's patently obvious that within the context of a particular relationship, neither is realistically an issue. And I sense from the jurisprudence a move to a more flexible approach to capacity assessments in terms of sex, for example, which will not look at artificial concepts, but to use the phrase of the Vice President, who is, let's face it, a wordsmith, applied in a way which is sensitive to the particular circumstances of the case and the individual involved. And Vice President emphasised a principle which is a feature of child protection jurisprudence as well, and it's referred to and had been referred to by Lord Justice Ryder in two cases as the child protection imperative, which is that we are driven to a particular outcome by virtue of applying the child protection imperative. And the approach that the Vice President was urging was that the professional instinct to achieve that which is objectively in P's best interests should never influence the formulation of the criteria on which capacity is assessed. In other words, substitute the word child protection imperative for the word adult protection imperative. Do not have an agenda is effectively what he is saying, which looks at the adult protection imperative in order to arrive at a conclusion on somebody's capacity. And then Poole J emphasised this, that the bar should never be set unfairly, should never be set too high as to be unfair, unnecessary, or discriminatory against the mentally disabled person. And that links in with the principle that the person must understand the salient information, but not all the peripheral detail. The reason why I emphasise these parts of the judgment is because they formed an important analysis of the judge's subsequent approach to the proceedings, but also his subsequent discussion and guidance in relation to the preparation of expert evidence. And the judgment is a decent and nice summary of the guiding principles which should always apply in the way, first of all, capacity assessments are undertaken, but actually more important for those of us who are involved in the forensic analysis of capacity assessments, how we should be approaching reading expert evidence, reading Section 49 reports, and reading other capacity assessments, including those prepared by best interest assessors and social workers. It's an important principle to follow the wording of Section 1, 2, and 3 of the Act, but also some of this jurisprudence isn't about relevant information. It's about general principles of not setting the bar too high and analysing the evidence properly. So in the case, and because of the expert evidence, the parties, after the expert gave evidence, made some submissions to the judges to some of the concerns that arose. And there were a number of concerns. One was that the approach to the capacity assessment was flawed because P had not really been given proper information prior to her assessment, nor had she been assisted in understanding, retaining, and being able to use and weigh the information. So what Poole did is break down the concerns, one of which was the first one there on the first bullet point, which is it is important not to assess someone's understanding before they have been given relevant information about a decision. Now, that fits in with another one of the Vice President's assertions in another case, which is a person who is not prepared or not made aware that they're having a capacity assessment or undertaking, that a capacity assessment on them is going to be undertaken. That assessment runs the risk of being regarded by the court as being flawed. And the simple reason for that is that somebody who is faced with having to do a capacity assessment without being given an opportunity, for example, to be told what the relevant information may well be, or not being aware that they're actually having a capacity assessment, that is defeating one of the cardinal principles of the Act, which is that all practicable steps must be taken to support the individual before a decision is made as to whether they have capacity or not. The second area was, I'll just move over the slide. Sorry, the third area was this business which I talked about earlier, which is the expert at different times having reached a different conclusion about P's capacity. The issue in the case wasn't that the expert had changed his mind. Indeed, sometimes we want experts to change their mind. The problem was that the change in mind in terms of capacity could not be justified in the reports. And there was no clear explanation as to why the expert had changed his view. And the evidence, which then underscored the change view. And one of the issues as well was that one of the assessments on which the expert had changed his view was without a face-to-face assessment of P. And we knew that the pandemic was on. We were dealing with this case during the pandemic. But that wasn't an excuse nor a reason for the expert's approach, flawed approach, to the evaluation of the evidence, and more importantly, to how he had changed his mind. And then finally, the expert had reached on a broad brush basis conclusions without looking at each decision separately. And we all know it's a fundamental principle of how we approach capacity, that decisions are specific. It's a specific decision. And there was this lumping together by the expert of lots and lots of bits of relevant information. And it was very difficult to see precisely what the relevant information related to in terms of the individual decisions. And then there was this issue of the brick wall. The expert was really, really concerned, frustrated that he'd hit a brick wall in his attempts to have a discussion with P, particularly the final interview. And this was a real issue about what the expert had done to try and engage her, what support had been given to her. Did she really understand the purpose of the interview? in terms of the significance for what she ultimately wanted, which was to leave the home and to marry CI or to live with him. And why hadn't the expert sought, at the point of realizing that he'd hit the brick wall, to drill down further, to be creative in engaging P in his assessment? And one of the issues was, what do you do where you actually think that P's just simply saying, I'm not engaging in this. So it's not a manifestation of their underlying impairment in the function of the mind or brain. They're actually just being stubborn or awkward. And there'd been no analysis by the expert as to whether that, in fact, was part of the problem, in which case you would then seek to address that through explaining to her the importance of engaging in the purpose of the interview. And that flowed on to the next issue, that there was a lack of cogent explanation as to why the presumption of capacity had been displayed when the expert had hit a brick wall, and it was unclear from the evidence was whether the brick wall was a manifestation of her underlying condition, or whether it was simply that she did not want to speak to the expert. So there was some basic failings in terms of the analysis, which then led to the conclusions that P lacked capacity in a number of areas. And at the end of the expert's evidence, it was the local authorities' position, supported by the other parties, that there was a need for another expert to look at the case. and the judge then had to make a decision as to whether he was going to hand down an interim judgment on the issue to offer some guidance. And one of the concerns of all the advocates in the case was to make sure that this was a judgment which reflected the difficulties in the case and was not too harsh in terms of the criticism of the expert. And there were a number of concerns in relation to how the court should approach that. And one of the concerns, of course, being that there is a dearth of experts in reporting in the Court of Protection, and we didn't really want a judgment that would put experts off from reporting, because we'd just received the working party report in family proceedings, where one of the criticisms was that experts were finding as a reason for not doing experts report in family proceedings the fact that they found the challenges of cross-examination in particular very difficult. And there was a feeling on behalf of some of the experts that they were not being treated particularly fairly by either the advocates or the courts. So it's well worth a read in terms of the judge's approach to that issue. But he did give some guidance, and it's really important guidance as well to experts. And the starting point was the expert is not undertaking just a clinical assessment, but he is undertaking a report to assist the court in the defined, identified areas in the letter of instruction. And this was really important, that the expert should pay close regard to the terms of the MCA and the Code of Practice. And so far as capacity is concerned, parts of the Code of Practice, which much of it's out of date, but in terms of capacity, a lot of it's still relevant. But it really was important for the expert to heed the letter of instruction as well. And let me just tell you, I've noticed increasingly, particularly before Tier 3 judges, High Court judges, a a scrutiny, an increasing scrutiny, where we are critical of experts, of the letter of instruction. Getting the letter of instruction exactly right is becoming very, very important. And maybe that's something that may well in due course be addressed during this course of lectures. I don't know, but really we have to be absolutely spot on about letters of instruction. And you'll see it be there. In fact, the letter of instruction in this case was a model of clarity in terms of it identified the decisions under consideration. It identified, without being prescriptive, what the case law said the relevant information was. It explained the need to consider the diagnostic and functional elements and the causal relationship between the impairment and the functional test. And what the judgment said was that the expert should really structure their reports having regard to the letter of instruction, the points set out, the issues identified in the letter of instruction. And so often as an advocate, when you're cross-examining an expert, the things that aren't there provide the nuggets, the little bits of gold, which enable you to test the expert evidence robustly. And we know, don't we? We've all been in those cases where we've asked questions about the expert, about where do you say in your report that you have applied the presumption of capacity? Or where do you say in your report that you've considered the issue of an unwise decision? The latter, of course, being particularly relevant to questions about using and weighing information. And Mr. Justice Poole said it was important to the parties and the court that experts set out in their reports that they have understood and applied the presumption of capacity and the other fundamental principles set out in section 1 of the MCA 2005. So, for example, it's really important that we look at the presumption of capacity, unwise decision, but also the issue about taking all practicable steps as well. The next part was that the expert should not address capacity issues with broad brush conclusions, and that the expert should set out the specific decisions, the specific information, which they say justifies a finding that a person lacks capacity to make the relevant decision. And also, really important as well, is that the evidence should ensure, the report should ensure that the opinions in relation to each decision are consistent and coherent. Now, this wasn't an invitation to experts to try and justify the difficulties over some of the jurisprudence. For example, how can you have capacity on contact, lack capacity on contact, but have capacity on sex, for example, which often perplexes some experts. Well, the judge wasn't saying try and make that fit in each case. This was much more basic stuff than that. This was stuff about previous reports being inconsistent with subsequent reports and not explaining it. And this was important as well, that the expert should explain the basis of each opinion, because the court was unlikely to give weight to an opinion unless it knows on what evidence it was based and what reasoning led to it being formed. So we know from the judgment then that the new expert was instructed, and this case actually made the law reports in in the Daily Mail. Yes, sorry, not the law reports in the Daily Mail. A scandalous headline in the Daily Mail, as you can imagine. And this was because the judge found that she couldn't decide where she wanted to live, or the contact she wanted with others, or care. But she could, about care, but she could make decisions on contact with others and engagement in sexual relations, but also that she couldn't and lacked capacity to make decisions about marriage. And this was discussed in great detail in the Daily Mail, as you can imagine, under one of its normal headlines on these issues. But it was an example. And again, this second judgment is a very clear example of how the courts approach evidence, particularly evidence from experts in relation to the relevant information. So you've got a second report, which is a report which is on Bailey again from January of this year. So my view of this case is that assessment and interviews are really, really important. Experts need to be told to set out the detail of the exchanges really between themselves and P, because that is really the basic information which you then feed in to your ultimate analysis in terms of the test under sections 1, 2, and 3 of the Act. The analysis is important, and I think we've all had experience then of brick wall cases, and it's important for the experts to ask themselves, is that brick wall a manifestation of their underlying impairment? Or is it simply because they are being extremely difficult and awkward because they have very strong views about their capacity to make the relevant decisions? And then I just want to emphasize this. This was a case about expert evidence. But the judge was very clear about this, that this guidance is not just limited to expert reports under Rule 15, but it applies to Section 49 reports, assessments by social workers, and this really is important, assessments by best interest assessors. So they're all in the frame for having to follow this guidance. And that becomes important and feeds into the next case I'm going to refer to, which is Hillingdon. I'm not going to go into great detail about the facts of this case, but this was a Section 21A appeal. It was in front of Hayden, and I will come on to his judgment in a moment. And there was one of the issues in the case is what should the court do on a Section 21A application? What's its powers? Because the wording of Section 21A is limited. And we know from the Briggs decision that you can't just say, in order to get funding, well, we'll call this a Section 21A, when in fact you're not challenging the deprivation of liberty. What you're challenging is aspects, for example, of medical treatment, or challenging other aspects of welfare decision-making, which really doesn't impact on the question of deprivation of liberty. So we already were in the territory of a restricted approach to Section 21A applications. And then this case came along. And the argument here was, if I go to the next slide, by Tor Butler Cole, who said that as a matter of general practice, the court should not make an interim orders in a Section 21A application. In other words, Section 48 wasn't available to it. And that the only question for the court is whether the criteria in Schedule A1 is met. And that if an interim order is going to be made, it should only be made if there is a sufficiently clear evidential basis to do so. So what I think Tor's first submission is that you've got your standard authorization. That's the vehicle through which you authorize somebody's deprivation of liberty. And the only question for the court is whether on the face of that documentation, the qualifying requirements are met. So it would literally, on the first argument, be scrutiny of the documentation before the court, because that's what the supervisory body looked at. If you take it through to its logical conclusion, whilst the supervisory body can go back and ask the best interest assessor or anybody addressing one of the qualifying requirements for further information, I don't think I've ever seen it. I can't recall seeing it. I think I would remember it if I'd seen it. So what the court should do is look at what the supervisory body had and no more. And all that they would have had is the standard authorization, the best interest assessment, the age assessment, the no refusals assessment, the mental health information, the mental capacity assessment, all that. And it should scrutinize that. And the whole starting point, as I understand it, was if you're not satisfied on the information set out there, then you should terminate the standard authorization. And that didn't appeal at all to the vice president. He preferred her second submission, which was that the court had the power to make orders to gather further information. And in his judgment, by the way, he was talking about striking the balance between protecting P's autonomy and promoting P's welfare. He considered the first approach, as I've already said, to be too rigid. And he emphasised the use of the word determine. The court has to determine it, which for him was an indication that the court had the power to obtain further evidence. But there were some important then exchanges between the judge clearly and counsel in the case. And this was what was said. I think this is really an important part of the judgment. All counsel agree that an application made pursuant to 21A does not permit the making of an interim declaration pursuant to section 48. And it looks as though the agreement was further. They submit that section 48 itself does not permit the making of interim declarations, notwithstanding that this is almost universally the practice. So what was being argued or was being said to him was, not only can you not make section 48 orders under section 21A, but even on an application of sections 15 and 16, there's no power to make interim declarations. There's a power to make orders under section 48. There is reason to believe that P lacks capacity, but there wasn't a power to phrase that as though it was an interim declaration. I could spend all day looking at that particular bit, but I'll just read the rest of it. As set out at paragraph 29 above, section 48 provides for the making of an order or for the giving of directions. It does not provide for the making of a declaration. Thus, the court's finding that there is a reason to believe that P lacks capacity ought strictly not to be phrased in declaratory terms. Ms. Butler-Cole also argues that as the COPR 2007 describe interim declarations as a remedy, there can be no interim remedy in a section 21A MCA application. As P is deprived lawfully of his liberty under a standard authorisation, the only remedy, it is argued, must be termination or variation of the standard authorisation. Now, I just want to stop there because what I couldn't read, and I've read this judgment numerous times, and no doubt at some point we'll have the chance of seeing what the Vice President's take on this is, but I didn't see him necessarily in the judgment agreeing that section 48 does not permit the making of interim declarations. I didn't see him saying that's absolutely right. When I read this, this is an argument which he accepted from all counsel. I think, however, when you look at the wording of section 48, it's probably right that there isn't a provision in there for the making of an interim declaration. All it is that the court makes an order in the terms set out in section 48. So we know it's a relatively low threshold. And so this is one of the reasons why we've now effectively abandoned on many applications using Section 48 as a vehicle for interim declarations. So we no longer see in orders, and it is declared in the interim pursuant to the provisions of Section 48 and Section 15 that P lacks capacity to conduct the proceedings, etc., etc. What they've been done now is they've been put in, we put them in as recitals. And then the judge looked at the issue of Section 48. Okay. And I'm just going to run through these quickly, which is the words of the statute in Section 48 require no gloss. The only question is the reason to believe P lacks capacity. In only wording which the Vice President could have used, the question stimulates an evidential inquiry in which the entire canvas of the available evidence requires to be scrutinised. So in other words, you can look across the board for that evidence. It doesn't necessarily have to be under Section 48. It doesn't necessarily have to be contained in formal capacity assessments. You can look at the full canvas. And Section 48 is a permissive provision in the context of an emergency jurisdiction. And listen to this really important word in which he emphasised, which can only result in an order being made where it is identifiably in P's interests. This is really important stuff, actually, because I think too often we fall into the habit of making orders that somebody lacks, for example, capacity to make decisions on contact or make decisions about social media access, without scrutinising the very reason why we're asking for that order to be made. And the emphasis here is that, you know, Section 48 can represent a significant interference in somebody's fundamental rights, because the evidence may well be relatively weak on capacity, and yet we then seek to make lots of orders restricting the individual's rights and freedoms. And what the judge is saying here is, you've got to justify that, because we know in the Court of Protection, these interim orders, they've been going on for far too long. And then you get to the end of the case, and the expert comes along and says, P's got capacity to make these decisions, like what happened in the AG matter above, where they were stopped from engaging effectively in intimacy, even though the lady had capacity to do it. And he emphasised this, that the presumption of capacity applies with equal force when considering interim orders under Section 48, as in a declaration pursuant to Section 15. And that's, again, a really important point of practice, which is the presumption of capacity isn't just for the last hearing, for the final hearing. It applies at every single point where a decision maker is seeking to interfere in a person's rights and freedoms. And I just want to emphasise this then about what he said here, that the exercise required by Section 48 is different from that set out in Section 15. The former requires a focus on whether the evidence establishes reasonable grounds to believe that P may lack capacity. The latter requires an evaluation as to whether, in fact, P lacks capacity. You've got to go back to that point there, the point about the presumption of capacity, when you are focusing on the lower test in Section 48. And then he said this, that the court does not become responsible for authorising P's deprivation of liberty upon issuing of a Section 21A application. The court's function is to review the authorisation which is in force. Now, I don't know whether the judge was emphasising in particular here the responsibility of the court at the point of issue only, because it's curiously worded. The court does not become responsible for authorising P's deprivation of liberty upon issuing of a Section 21A application. And I'll come on to that in a moment. And then this is the real get out for all judges, this in my view, which is the objective of Section 48 is neither restrictive in the sense that it requires a high level of proof, nor facilitative in the sense that it is to be regarded as a perfunctory gateway to a protective regime. Sorry, that should go down that Roman numeral. There is a balancing act in which the court is required to confront the tension between supporting autonomous adult decision-making and to avoid imperiling the safety and well-being of those whom the judge and the judges are charged with protecting. So, on the one hand, you've got all this jurisprudence about saying you shouldn't be driven in capacity assessments by looking at the adult protection imperative. And then the next part of the equation when you look at this is that really judges have got to, at the interim stage, they've got to be very careful to look at the balancing exercise between autonomous decision-making and imperiling the safety and well-being of those whom the Act and the judges are charged with protecting. My instinct there is, if you were a judge, you're likely to say, that's my best card, that I'm going to make this order because I know if I don't, there's a real likelihood that I will be imperiling the safety and well-being of those whom the Act and the judges are charged with protecting. So he dealt in this judgment with two aspects of the case. 21A, so you can't make Section 48 orders in terms of the issues which arise in a 21A, and then also dealt with the issue of Section 48 itself. So you can't make Section 48 orders in a Section 21A. But I just want to raise these issues with you. We know that the standard authorization is the legal vehicle for a person's deprivation of liberty. The court is reviewing the assessments. So the quality of the assessments has to be carefully scrutinized. And I just want to say something about statements of facts and grounds. We have got to be more bespoke now in the light of what we're saying here about our arguments about the quality of the capacity evidence. And I'm just saying this from my experience. The issue about Section 49 reports in the Court of Protection and expert reports is a major problem at the moment, because a lot of trusts are saying, because of the pandemic, we can't do it. We're struggling to get on with it, etc., etc., etc. And I'm noticing one or two really good Court of Protection judges asking at the first hearing, the first substantive hearing, for justification as to what is wrong with the actual assessments that have already been undertaken. In other words, the Schedule A1 assessments. Why do they in fact fail to address or rebut the presumption of capacity? And they're looking at grounds. Some of the judges are scrutinising the grounds very carefully. You'll know who I mean. One on this circuit, and definitely one on the Northern Circuit, looking at the statement of facts and grounds to say, well, what's your argument here? So you need to, when you're drafting your grounds, to really focus in on what you see are the deficiencies in the actual assessments. And I emphasise this, try and utilise what Mr. Justice Poole set out in AG above. And if there's a really serious issue about capacity, and on the face of the assessments, presumption is not rebutted and it's really weak, do not be afraid to be saying to the court, either at the first hearing, in advance of the first hearing, or at the first hearing, Judge, we require a really urgent hearing on peace capacity, and we want the best interest assessor or whoever has done the capacity assessment to give evidence. I've done it. I've done it. The day after this case came out, the best interest assessor was called to give evidence as to their assessment, and the judge was really troubled by it. The judge was really troubled by the nature of the evidence that had been given. Didn't terminate the standard authorisation, but it was sufficient for the judge to say two things. One, what's the quickest way of getting a report here on capacity? Is it a section 49, or is it going to have to be a rule 15.3 instruction? And it was a 15.3. And eventually that report came back saying that the person had capacity. So don't be afraid at the first hearing of saying to the judge, I'm sorry, judge, you're going to have to make time in the list for a contested hearing on capacity. And then these points about section 21As, because the standard authorisation is the vehicle through which the deprivation of liberty is authorised, there's no need to refer in the orders. You can't refer in the orders on the face of it to section 48 interim orders on those decisions. There's no need for it, because the standard authorisation is the vehicle through which the deprivation of liberty is authorised, the subjective, objective, and imputability to the state tests. But we all know, don't we, that when you get a section 21A in, there are other areas of capacity which arise: contact, sexual relations, social media. And it's clear that in these cases, that the court then has to make some recording in the order, and we do it now by effectively the recitals in the order, applying the strict wording of section 48. I just want to take you back to this. Remember where the judge said the court does not become responsible for authorising P's deprivation of liberty upon issuing of a section 21A application. The court's function is to review the authorisation which is in force. What I've yet to be clear in my own mind about is, what if the court then decides to extend the standard authorisation? The court then is taking responsibility for it. So how does the court approach that within the context of looking at the wording of an order, or what the court should be scrutinising when it extends the standard authorisation? Okay, I should say what you can do under section 21A applications. The court can still make orders for seeking further information. That's absolutely clear from Mr. Justice Hayden's decision, that in order for the court to determine whether a qualifying requirement is met, it can order evidence on any area, best interests, capacity, whatever. Okay. And then the third case, I've got 7 minutes to deal with this. This is a really interesting case, because this was an application by a mother, stroke stepmother, to be joined as a party to proceedings. And this is the procedural issue which arose. Well, the first instance judge, which was our own Judge Hayes in Leeds, and the appeal was then to Mr. Justice Cobb. And this was the crux of it. At the hearing before the judge, the local authority and the official solicitor presented and sought to rely upon information which, although acknowledged to be relevant to the issue before the court, they wished to keep confidential from KK, the confidential material. The judge received this documentary material and read it. Neither KK nor her lawyers were given access to this material. The judge gave a separate shorter judgment, which I shall refer to as the supplementary judgment, in which he expressed his view about this confidential material and its significance to the decision. So the judge gave two judgments. Okay. These were KK's case on joinder. She said, I occupied an important decision in DK's life as a primary carer. She disputed she exerted any proper degree of influence over DK. She wanted to assist the court to determine the facts by the court of protection relevant to welfare issues. And she said, I can help on that. And the only way you can determine the question of my input in the proceedings and my party status is to see the evidence that is for me to see the evidence that is relied upon, which she hadn't seen. She wanted to see it. It was accepted that the court could exercise its case management powers to control what KK could not see as a party. And it was put by Ben McCormack in excellent submissions that the way of striking the proper balance between the claim need to protect DK by preventing KK from seeing particular aspects of the case and the need from the court to hear from a Coast family member as to the issues at the heart of the case was by allowing her to be a party and controlling the evidence that she then saw. It was emphasised that KK should be able to participate. She shouldn't be sitting in the wings, but in the theatre. And that in order to ensure fairness and the parties were on an equal footing, KK should be joined as a party. The opposing arguments, which were those of the local authority and the official solicitor, it was accepted that it would usually be the case that a parent of a young person who is the subject of proceedings would have party status. The position in the Court of Protection is different to those in the analogous jurisdiction of the family proceedings, particularly where it's not proposed or a realistic option for P to reside with or be cared for by an applicant or a prospective party. It was emphasised that disclosure impinged on P's privacy, but where there was a conflict between Article 6 and Article 8 rights of DK and KK, DK's best interests must prevail. It was currently in DK's best interest for a contact with the family to be supervised, and that there was a degree of consultation with KK in relation to best interest decisions, which would continue regardless of the proceedings. This is what the judge at first instance stated. He was satisfied that the reasons for not revealing the written evidence to KK were valid, and that the necessity for redaction is rooted in DK's best interests. If the information was revealed, it was likely that DK would disengage from the proceedings and from her engagement with professionals. That would apply even if KK was joined as a party to the proceedings, but that would inhibit DK expressing her true wishes and feelings and undermine the process of ensuring her effective participation in the proceedings. Accordingly, the weight to be given to that evidence is significant as to the effects of joinder, not just disclosure, but joinder, and that this wouldn't be resolved by joining KK as a party and then exercising the court's power to redact or limit disclosure. The effect of joinder in itself will bring about adverse consequences for DK. There were two grounds of appeal. First of all, the closed procedure that was, I'm going to use that phrase just as shorthand. The procedure which was adopted, which was that KK did not have disclosed to her either the evidence or the submissions, actually offended the principle of open justice, robbed the judge of the potential to make proper determinations, and rendered the proceedings unfair, and that the judge erred in adopting such a procedure where there might have been alternative methods for dealing with the proceedings. 2 points from this case. First of all, joinder. Joinder is a two-stage test. The first is that the person must be able to show sufficient interest, and that is effectively a filter to stop those who have only a fleeting or trivial involvement seeking party status. But the second is that it's got to be desirable for the court to join the person with sufficient interest as well. So it's a two-stage test. Too often, we're a bit clumsy and we're a bit blind to this in the Court of Protection. We just say, yeah, you can have party status, you can have it. But applying the rules strictly, the question is, do they have sufficient interest? And the emphasis in the rules is it desirable for the person to be joined, even if they have sufficient interest? And the judge said, so I've put this as Cobb on Hayes. It sounds like a sort of nice town in Worcestershire or somewhere down south. It says, I am wholly satisfied. Indeed, there's been no issue taken that the judge correctly identified and applied the test on joinder and party status. So that emphasises the two-staged approach to joinder. And then the judge said this about the procedure that had been adopted. First of all, the general obligation of open justice applies in the Court of Protection, as in all other jurisdictions. A judge faced with a request to withhold relevant but sensitive information must satisfy him herself that the request is validly made. The best interests of P, alternative the interests and position of P, which is the overriding objective, should occupy a central place in any decision to provide or withhold sensitive information to an applicant. The greater the risk of harm or adverse consequences, the stronger the imperative for withholding information. The expectation of equal footing for the parties should be considered as one of the factors, not a determinative factor. And he said this, whilst the principle of natural justice are always engaged, the obligation to give full disclosure of all information to someone who is not a party is unlikely to be as great as it would be to an existing party. Now that's really important, because when you're agreeing to somebody joining as a party, the obligation, according to this judgment, is that is a route in to getting some of the information. Any decision to withhold information from an aspirant for party status can only be justified on the grounds of necessity. Okay. In such a situation that, in such a situation that Article 6 and Article 8 rights of P and the aspirant party engage where they conflict, the rights of P prevail, again emphasising the importance of the proceedings. They're about P. The judge should always consider whether a step can be taken to acquaint the aspirant with the essence of sensitive withheld material by providing a gist of the material or disclosing it to the applicant's lawyers. And the judge said, I suggest that a closed material hearing would rarely be appropriate in those circumstances. So if you can give the gist of the material, or you can disclose it to the applicant's lawyers alone, there's no need for a closed material hearing. And then he said this, it seems to me that a judge may well find, indeed would be highly likely to find, that it's necessary to withhold sensitive evidence information from a third-party applicant for party status in the Court of Protection, where disclosure would be likely to directly harm P or would otherwise indirectly or adversely affect P, such as by inhibiting P in his active participation in the proceedings. It must be remembered that the whole purpose of the welfare jurisdiction is to protect and promote the best interests of P. Proceedings must not become an instrument of harm to P. The proceedings must not become an instrument of harm to P. And one mention, as I come to the end, you can read that in due course. I made the point in that case that that my client, who was P, didn't choose to bring the proceedings, and the judge accepted that there was all the more reason why she should not be now put in a position where her rights and her privacy are challenged or compromised by the process which is designed to protect her. So what's the learning from this? Well, applications for withholding information will be very rare and should be rare. there has to be a clear evidential basis for arguing that the impact of joinder or disclosure on P, you can't just have a general assumption or assertions. You've got to have some specific work undertaken, which had occurred in this case over a period of time. The evidence was there. And this is important as well, that the litigation friend is under a duty to competently and fairly conduct the proceedings. And the central role of the litigation friend is to obtain P's ascertainable wishes and feelings. And it really is important in those cases where you know this is going to be an issue, to identify early whether party status should be opposed and to find out what is in the evidence that the statutory authorities may well have. Because you may well find that you've agreed to somebody having a party status, and then what you subsequently want to do is withhold them information from them. That becomes a really tricky exercise. And you will be able, from your own experience, to identify early on the section 15, 16, or even 21A cases where you think that this issue may well arise. So just be really alert from day one, if you are representing the OS or a litigation friend, as to the potential issues that may well arise in cases where you may subsequently want to control disclosure, and whether in fact you realistically should be opposing joinder at an early stage. And I just want to finally say this: disclosure to lawyers only, I wouldn't do it. I would not do it. I think it is a recipe for bringing relationships to an end with clients, and also for your own professional conduct going forward. If your client then seeks to sack you, what do you do with your files, etc.? So those are the three cases. I'm sorry, I'm slightly over the time limit, 7 minutes. Any questions? I'm sure they'll be fed through to me. I won't give any answers. That was a joke, Alison.
I appreciate that, Joe. I'm just trying to get myself back on video. It may well be that I can't do that. Can everybody hear? Can you hear me? Because if you can, everybody can.
I can hear you, and I now can see.
There I am. Excellent. Thank you so much, Joe. That was extremely informative and a really good summary of those three cases. So thank you. I've got several questions, and I'm going to pick a couple if that's okay. I know you said, Joe, that if they're too difficult, you would pretend your internet had gone down. So
I would.
I'll pick the ones that.
Yeah.
So the first one is when thinking about capacity assessments and avoiding artificial silos, how does this apply when looking at P's care arrangements? Capacity is often assessed in terms of capacity for residence and capacity for care separately, when the two are often inextricably linked. I've just gone down too far there. Sorry, this is my superb techie skills. Inextricably linked. Should we do away with these silos and look at P's capacity? Let's jump again. P's capacity to make decisions about their care and residence arrangements as a whole. And I know that's something that's come up in several of my cases recently.
I don't think you should. I think you should start from the starting point that residence and care are separate decisions. But if you then get to the point where you say that you cannot reconcile the outcome of a decision on residence with the outcome of a decision on care, that you should do what the Court of Appeal did in Re B, which is to say you can't make these decisions in isolation. But I know that that's a nuanced approach to it, but I still prefer the approach. Can somebody decide where they want to live? Can they make the decision about the care they need? And I accept in the majority of cases that they do overlap, but I do like to have a starting point that those are separate decisions, but they do overlap. But I don't think you should get away with it. Otherwise, you're really saying, what care do they need?
Thank you, Joe. Another question, really helpful, brick walls. Do you have any comment on how this applies to the Mental Health Act? And can practice from mental health assessments be relevant to MCA assessment? Recalls are very common in mental health assessments. Corroborative information is used, history from family, police, for example, to make decisions about whether a person meets the criteria for detention. And that's from Dr. Grace.
Well, I knew is that Dr. Janet Grace?
Yes.
Who's asked that? I knew she'd ask a really difficult question. I think there is a lot to be learned.
Turn your internet off now, Joe. Perhaps turn your internet off.
Yeah. Yeah, I think there is a lot to be learned from how it's approached in terms of mental health assessments. But I think the brick wall issue is a very, very difficult issue in certain areas. Particularly those who have got underlying neurological conditions, as opposed to something, for example, such as dementia. I think it's a very, very difficult area to delineate between somebody who is saying, I don't need a capacity assessment, and they're being stubborn over it, and somebody who actually, as opposed to that being a manifestation of their underlying impairment. I sounded like Nicola Sturgeon or Alex Salmon there, didn't I? I didn't answer the question.
Not quite. just one more question. It's regarding the Hillingdon case.
Yeah.
So unfortunately, since Cheshire West, the waters between good MCA practice and welfare activities and doles has been blurred. I have seen some doles authorisations with attached conditions from BIAs that do not relate to the detention of P, but to other elements of the care plan, such as literally the condition making sure P's dentures are found, personalising P's room, updating capacity assessments and best interest paperwork. These should not be conditions. These activities are good care management and meet the general compliance with the Mental Capacity Act. I think there should be more recommendations to address any welfare concerns. I think that's more of a comment really than a question.
You have to be very careful about conditions on standard authorisation. Have to relate to the issues surrounding deprivation of liberty, and also as to what the managing authority can do. It's about the managing authority. Conditions are directed towards the managing authority, and that's a really important boundary mark for the extent of conditions. I quite like conditions, though. I think they tend to focus the minds of those who are responsible for the deprivation of liberty on what the issues are.
And just by way of comment on that, I know that recently you've advised that conditions are put on the standard authorisation for reporting any objections and to any outbreak of coronavirus in the care home. I think that's been adopted as practice quite often now.
Yeah.
Well, can I just say thank you?
Can I just explain the reason why that's been one of the reasons why that's been adopted is because within the restrictions that are then imposed on a person who's got COVID are increased restrictions in the placement that they're at. That's why the isolation issue. That's why that becomes important. Yes. And I know that some authorities regard that as controversial, but in my view, it's directly relevant to the issue of a person's detention in a particular place. How restrictive is their detention?
Yes, indeed. And Professor Wayne Martin, we're talking about the restrictions in care homes over this pandemic period. So that's the next lecture today, actually. So can I just say thank you so much, Joe, for your expertise and the time that you've given us all this morning. You've been fabulous as usual. I can't go through all the questions because there just isn't time to do that. Maybe I can email those to you over the next few days. So thank you very much, and thank you for everybody attending.
I assume nobody's asked when I'm getting a haircut.
No, that doesn't come up on the list of questions so far.
I'm pleased. Thanks very much, everybody. I really hope to see most of you soon. Thank you. Bye-bye.
Thank you all. Bye-bye.